It was the early hours of the morning, February 22nd, 2017. Picture this. You're in a police station, mid-north coast of New South Wales. Deep, quiet, middle of the night kind of vibe. Inside, there's this stark interview room. A young man sits there. He looks exhausted, vulnerable. His mother's beside him.
Right.
The air is just thick with tension. You can feel the stakes are really high. It's a serious criminal investigation unfolding. And then you see it, that little red recording light blinks on.
Yeah, the blinking light. It signals the start of what police call an ERSP, an electronically recorded interview of a suspected person. It's supposed to be this tool, right, for fairness, accuracy, capturing exactly what's said between police and a suspect.
Supposed to be.
But in this specific case, with this particular young man, well, that blinking light kicked off a whole chain of events. Years later, it all unraveled in the highest criminal court in New South Wales. And it casts this really harsh, uncomfortable light on police procedures, especially around how vulnerable people are treated.
Yeah. The young man in that room was Mann. He was only 22 when that interview happened. And even younger, between 18 and 22, during the time the alleged crimes took place. Now, Mann is an Indigenous Australian man, and he has a known intellectual impairment. And this is just absolutely crucial. Under NSW law, specifically something called the LEPRA regulation, that's the Law Enforcement Powers and Responsibilities, regulation. This legally defined him as a vulnerable person.
And that label, vulnerable person, it's not just descriptive. It triggers specific legal safeguards, rules the police have to follow when they're questioning someone like Mann. Non-negotiable rules.
Right. And here's where the whole story really hinges. The core conflict, it actually started even before that red light started blinking.
Yep.
This interview, this ERSP, it was obtained even though Mann had clearly been given legal advice not to do an interview, and he'd accepted that advice.
Explicitly accepted it.
And his mother, who was there as his legally required support person, she told the police he didn't want to speak. So you've got all these layers of protection supposedly in place, and the interview went ahead anyway. And the things Mann said in that interview, they became the key evidence, sometimes the only evidence, the prosecution used against him on these horrific child sexual abuse charges.
It's quite something when you lay it out like that.
So that's our mission in this deep dive. We're going to peel back every single layer of this case. It's known formally as Mann v. R. The R stands for the Queen, or now the King representing the Crown. The citation is 2023 NSWCCA 256.
Right.
We're going to, walk you through exactly what went down in that police station, why it happened, and maybe most importantly, what the fallout has been. Not just for Mann or the family of the alleged victims, but for the whole justice system here in Australia.
Yeah, think of it less like a dry legal judgment summary and more like a procedural true crime story. But we're sticking strictly to the facts, the sources, the court findings.
We'll look at how this confession, which seemed so critical at first, just sort of crumbled under legal scrutiny later on appeal.
We'll cover that first legal fight, the voir dire. That's the pretrial hearing where the defense tried to get the interview thrown out.
Saying it should never see the light of day in court.
Exactly. Then we'll talk about the jury trial itself where, well, that argument failed initially. The tape was played, and Mann was convicted based largely on it and other evidence.
And then the big one, the appeal, where the court found, and this is their term, substantial impropriety in the police conduct. And convictions started getting overturned.
Yeah, a really significant finding.
We'll need to dig into some of the key legal ideas here, too. Things like Section 138 of the Evidence Act in New South Wales. That's the rule about excluding improperly obtained evidence.
And specifically, one part of that, Section 138, Thes 3, it sounds technical, but it's about how hard it would have been to get the evidence without breaking the rules. The appeal court found the first judge got that bit fundamentally wrong.
Right. And we also need to explain something called a House v. the King error. Sounds grand, but it's basically the legal test for when an appeal court can step in and say, nope, the trial judge made a mistake in how they used their discretion. Finding that type of error was the key to unlocking the whole appeal.
Absolutely critical, because this case, it's way more than just about one person, one interview. It has genuinely changed how police and NSW are supposed to handle vulnerable suspects. It's hammered home the importance of respecting someone's right to silence.
So it's a story where you see these really high principles, the rule of law crashing right into incredibly serious criminal allegations, and it forced the justice system to kind of look at itself and ask some tough questions about how it gets things done, the means versus the ends.
Precisely.
Okay, let's really get into this complex story then. To understand the legal fights, we have to understand the sequence of events first. How did Bowman even end up in that interview room? And as we go, we'll introduce the key players, the sort of dramatis personae in this whole narrative.
Okay, so the whole thing starts, tragically, with a disclosure. One of the young children involved, a little boy known as MS, told his grandmother, JS, something had happened.
And JS, the grandmother, she was Bowman's former host. He'd lived with her family.
That's right, he had boarded with them for a period. So this disclosure from her grandson, that's what set everything in motion.
So what did JS do?
She contacted the police. Now, the sources say she initially might have intended to bring Bowman to the station herself. Maybe to cooperate, clear things up. We don't know for sure. But in the end, she stopped just outside the station. She didn't actually take him inside.
Okay, so she didn't bring him in. What happened then?
Well, police were called to her location. It was late at night by this point. And the sources mentioned police arriving, including a caged truck, which kind of suggests they were treating it seriously from the get-go, maybe anticipating an arrest.
Right. Who was the first officer to interact with Bowman?
That was a Sergeant Kirk. He found Bowman actually asleep in the back of JS's car. Apparently, Bowman had been doing some hard physical work, fencing all day, and was just exhausted. Sergeant Kirk had to wake him up.
Woken up by police late at night? Not ideal. What happened right then in the car park?
Well, this interaction is really significant because it happened before Bowman was formally arrested for the specific charges he later faced. And critically, it wasn't electronically recorded.
Okay.
Sergeant Kirk gave Bowman what the judge later described as a limited caution.
Limited, so not the full warning about his rights.
Exactly, not the comprehensive one.
Yeah.
Judge Madgwick, who heard the evidence challenge later, he's an associate district court judge, a senior judge, he found Sergeant Kirk's actions here involved only sort of minor improprieties, but it was still important. Kirk told Bowman he'd spoken to JS, the grandmother, about what MS had said.
Right.
Then he asked Bowman directly, do you know what that would be? And Bowman said yes.
Okay.
Then Kirk pushed further, well, what have you done?
And this is where the first admissions came out, unrecorded.
Yes, right there in the car park. Bowman replied, I touched and done stuff with him I should have not done.
Wow. Okay.
And Sergeant Kirk didn't stop there. He asked more specific, very leading questions, directly linked to the serious allegations. Things like, did you touch M on the dick? Bowman said yes. Then, did you stick your dick in M's bum and fuck him? And again, Bowman's answer was yes.
Okay, those are incredibly serious admissions made right there, unrecorded, after being woken up, before getting proper legal advice.
Precisely. And they happened before he was even arrested for those particular acts. It was only after getting these admissions that Sergeant Kirk formally arrested Bowman for having sexual intercourse with MSE. This was just after 10:50 p.m. He was then searched, handcuffed, put in the caged truck, and taken to Tawri Police Station.
So he arrives at the station. Who takes over then?
The custody manager, Senior Constable McSweeney. And her role here is absolutely vital because she's the one responsible for making sure the rules for vulnerable people, those LEPRA regulation safeguards, are actually followed.
Did she recognize his vulnerability?
Yes, the sources are clear on this. She immediately noted his intellectual impairment and his Aboriginal status. She correctly identified him as a vulnerable person under the law, and she started doing what the law requires. She called his mother, Miss Mann, to act as his support person.
Right. The support person is legally required for vulnerable suspects, isn't it?
Yes. And she also made preliminary contact with the Aboriginal Legal Service, the ALS. Interestingly, Bowman himself said he wanted his mother there with him when he spoke to the ALS lawyer, which kind of hints at his need for support, even just for that legal consultation.
And his mother, Miss Mann, she didn't live nearby.
No, it was a long drive for her, like 2.5 to 3 hours in the middle of the night. Senior Constable McSweeney kept in touch with her by phone while she was traveling.
Okay, so while everyone's waiting for Mrs. Mann, what's happening at the station?
Well, the investigating officer gets involved. That's Detective Senior Constable Gibson from the Forster region. He arrived around 2:30 a.m. Sergeant Kirk told him about those admissions Bowman had made back in the car park.
So Gibson knew about those initial statements?
Yes. And Detective Gibson then had a brief chat with Bowman himself while they were still waiting for his mother. He confirmed those initial admissions, and Bowman apparently added something like he'd been silly.
Okay. Then Miss Mann arrives.
Finally, yes. Around 3:45 a.m., exhausted, understandably. Senior Constable McSweeney then properly went through the procedures. She told Mrs. Mann about her rights and responsibilities as a support person, gave her written info, got her to sign an acknowledgement. Then she did the same for Bowman, informed him of his specific rights under Part 9 of LEPRA, gave him the full, formal caution. He also signed an acknowledgement, indicating he understood. And remember, the labor regulation specifically requires police to make sure a vulnerable person understands the caution. If it's given without a support person, it has to be repeated once they arrive.
Were they given time to talk privately, Bowman and his mother?
The sources say they had a limited opportunity, yes, which is another important safeguard. And then came what really is the absolute turning point in this whole sequence.
The call to the lawyer.
Exactly. The contact with the Aboriginal Legal Service. The solicitor on the phone was Mrs. Gidlow, and her advice was crystal clear, unequivocal. She told Bowman, say nothing. Do not agree to a police interview. Do not even go into an interview room. Full stop.
That seems a pretty standard, strong legal advice in that situation. Did Bowman accept it?
Yes. And this is critical. According to the evidence that Judge Madgwick later accepted, Bowman himself, or possibly his mother communicating for him, told Miss Gidlow they accepted her advice. He was formally exercising his right to silence based on what his lawyer told him.
Okay, so the lawyer gives clear advice, the client accepts it. What happens next? Does the lawyer tell the police?
Yes. Miss Gidlow immediately told Senior Constable McSweeney, the custody manager, about this. She informed McSweeney that Bowman, having received and accepted ALS advice, did not wish to be interviewed and did not wish to go into an interview room.
So the custody manager knows, the officer responsible for his welfare knows he's exercising his right to silence on legal advice.
Correct. And here's where things really go off the rails, according to the later court findings. Judge Madgwick, in that crucial admissibility hearing, made a key finding of fact. He accepted Senior Constable McSweeney's testimony that she did pass this information on. She told the investigating officer, Detective Gibson, that Bowman did not want to be interviewed based on the legal advice.
She told Detective Gibson, the investigator.
Yes. The judge specifically said he preferred McSweeney's evidence on this point over Detective Gibson's denial that he was ever told this.
Wow. Okay. So Gibson, the investigator, now knows the suspect is vulnerable, has a support person present, has spoken to a lawyer, has received advice not to speak, has accepted that advice, and the custody manager has told him this. What does Gibson do?
Well, this is where Judge Madgwick found Gibson's conduct became quite improper and deliberate. Despite knowing all this, Gibson approached Ms. Mann, the mother, not Bowman himself, but his mother.
Asking the mother, not the suspect.
Yes, which the judge thought indicated Gibson's own view of Bowman's limited capacity. He asked her if her son wanted to be interviewed, and Miss Mann told him again, no, he does not want to be interviewed.
So Gibson's been told by the custody manager and by the support person that Bowman doesn't want to be interviewed, based on legal advice. Surely that's the end of it.
You would think so. But according to Judge Madgwick's findings, no. Despite knowing Bowman's express wish, communicated multiple times, Detective Gibson proceeded to lead the applicant into the interview room without explanation and commenced the interview.
He just took him into the room anyway.
That's what the judge found. The interview started at 4:48 a.m., very late or very early, depending how you look at it. After Bowman had been awake for hours, driven to the station, gone through all this, the judge concluded that Gibson, quote, effectively required the accused to undergo the interview, contrary to what Dead Gibson knew had been and continued to be his desire not to be interviewed.
That sounds incredibly coercive.
The judge described it as a matter of serious impropriety and contravention of the legislation and of the accused's right to silence. He also noted that while Gibson did give Bowman another caution inside the interview room on tape, he significantly failed to ask Bowman or his mother if they were actually content to proceed with the interview at that point, or if they consented to participate, knowing the legal advice was to refuse.
So it's a clear, deliberate decision to ignore the suspect's wishes and legal rights, especially given his known vulnerability. What was going through Bowman's mind at this point? Did the judge make findings about that?
Yes, Judge Madgwick did. And his findings really underscore Bowman's vulnerability. The judge found Bowman did understand on some level that he had a legal right not to talk. He'd been cautioned, he'd spoken to a lawyer.
Right.
But the judge found Bowman felt he had no practical choice. He thought he'd be in more trouble with the police if he refused to speak. He also had this mistaken idea that because he'd already sent things in the car park, telling the full story now wouldn't make things worse.
The cat out of the bag fallacy.
Kinda, yeah. Plus, he just wanted to get it all out, get it over and done with. He wanted it off his chest. The judge felt Bowman didn't really grasp the full seriousness of the allegations, but he thought maybe lying to police would be even worse than telling the truth about what he'd done. It's this mix of confusions, naivety, exhaustion, perceived pressure. It all points to why those safeguards are so critical for vulnerable people.
And under those circumstances, feeling he had no real choice, the ERISP, the recorded interview, began. What actually happened during that interview? What did he say?
Well, the sources describe him as appearing confused, hesitant, mumbling responses initially.
Right.
The officers, Gibson included, apparently encouraged him, tell your side, get it all out. And eventually, over the course of the interview, he did make incriminating admissions. He talked about games he played with the children, and these descriptions amounted to serious sexual offenses.
And this tape, this ERSP, became central to the prosecution's case.
Absolutely central. And this is the kicker. For 18 of the 38 charges he eventually faced, the admissions he made in that interview, obtained under those circumstances, were the only significant evidence the Crown had. Without that tape, there was basically no case on almost half the charges.
18 charges hanging entirely on an interview obtained after the suspect said no, based on legal advice. That's quite something.
It really sets the stage for the legal battles to come.
Okay, so the interview's done. It contains these admissions obtained in highly questionable circumstances. How many charges did Bowman face in total?
He was charged with 38 offenses in the end, all relating to alleged sexual abuse of the two children, SS and MS, the siblings.
Over what period?
The allegations covered several years, suggesting ongoing abuse, and the charges were extremely serious, including multiple counts of sexual intercourse with a child under 10, which, carries a maximum penalty of life imprisonment in NSWs.
So incredibly grave charges. The allegations involved encouraging the siblings in these games and also directly assaulting each child.
Yes, that was the nature of the allegations.
Now, I remember the outline mentioned he pleaded guilty to some other charges. How did that fit in?
Yeah, that's correct. Early on, separate from the main trial on these 38 counts, Bowman pleaded guilty to 12 other charges. They related to the same children, but were dealt with separately, possibly as part of early negotiations or case management. Those 12 guilty pleas were later factored into his overall sentence, but they weren't the focus of the trial or the appeal we're discussing. The big fight was over the 38 counts, particularly the 18 relying on the ERSP.
Right. So with the ERSP being the only real evidence for 18 counts, the defense absolutely had to challenge its admissibility. They had to try and stop that tape being shown to the jury. Which brings us to the first major legal battle, the voir dire.
Exactly, the voir dire. That pre-trial hearing, essentially a trial within a trial just on the evidence question, this one happened before Judge Madgwick ADCJ in November 2018. The sole focus. Should the ERSP be allowed in under Section 138 or Section 90 of the Evidence Act?
Who was representing Bowman at this crucial stage?
He was represented by solicitors from Legal Aid NSW, who briefed counsel, a barrister, to argue the case.
And what was their core argument?
They argued, basically, that the ERSP wasn't just improperly obtained, it was illegally obtained. They said the police committed a deliberate, significant breach of Bowman's fundamental right to silence, a right protected by law. They hammered the point that the police knew about the ALS lawyer's advice, knew Bowman accepted it, knew his mother, the support person, said he didn't want to talk, and they went ahead anyway.
And they really pushed his vulnerability.
Absolutely. His indigenous background, his intellectual impairment, his age, his lack of experience with police, his naivety. The judge later specifically noted these things. The defense argued this vulnerability made the police conduct even more serious.
And the legal consequence they wanted.
Exclusion. They argued admitting the interview would be fundamentally unfair to Bowman under Section 90, and more broadly under Section 138, admitting it would damage public confidence in the police and the justice system. It would essentially condone ignoring safeguards for vulnerable people. So, they said, the judge had to exclude it.
Okay, strong arguments. What was the Crown's response? Who represented them?
The Crown was represented by the Solicitor for Public Prosecutions at this stage, who briefed a Crown prosecutor. Their argument was essentially, yes, maybe procedures weren't perfectly followed, maybe the detective was a bit overzealous, but look at the evidence itself.
This is reliable, it's important.
Exactly. They stressed the admissions were crucial, the only significant evidence for 18 very serious charges. They argued the truth-finding function of the court, the need for justice for the child victims, outweighed the problems with how the evidence was obtained. They urged Judge Madgwick to use his discretion under Section 138 to admit the evidence. They said its probative value, its ability to prove the charges was so high that the desirability of admitting it outweighed the undesirability of the police conduct. It was that classic Section 138 balancing act.
So Judge Madgwick heard all this. He heard about the late night, the limited caution, the ALS advice being ignored, Bowman's vulnerability, the seriousness of the charges. What did he decide? What were his findings?
He made some really detailed findings. First, he absolutely accepted Bowman's vulnerability, the intellectual deficits, ADHD, all of it. He also found unequivocally that police improprieties did occur.
What about Sergeant Kirk in the car park?
He called Kirk's caution limited and his conduct minor improprieties. Not the main issue for Section 138, but noted. He also found Senior Constable McSweeney, the custody manager, potentially didn't do enough to ensure Bowman fully understood the caution. He called that an unintended impropriety of moderate importance, but again, not the central problem.
The central problem was Detective Gibson's action.
Yes, that's where the judge's findings were strongest. He found Detective Gibson's conduct proceeding with the interview, despite knowing everything was quite improper, and crucially, he found it was deliberate.
Deliberate. That's a key word in Section 138 analysis, isn't it?
Hugely important. Judge Madgwick said Gibson's actions showed an attitude of mind that would effectively put at naught the protections established by the LEPRI regulations. He stated Gibson effectively required the accused to undergo the interview, contrary to what Det Gibson knew had been and continued to be his desire, not to be interviewed. He flat out called it a matter of serious impropriety and contravention of the legislation and of the accused's right to silence, and confirmed it was deliberate.
Okay, so the judge finds serious, deliberate police misconduct violating Bowman's rights. That clearly satisfies the first part of Section 138. The evidence was improperly or illegally obtained. So then it comes down to the balancing act, desirability versus undesirability.
Exactly. And this is the astonishing part, given those findings. Despite finding serious, deliberate impropriety that undermined the legal safeguards, Judge Madgwick concluded that the evidence should still be admitted under Section 138.
He admitted it. After all that, why? What was his reasoning for tipping the balance that way?
He gave three main reasons. First, he felt the admissions in the ERISP were largely true and reliable. Despite Bowman's confusion, they seemed genuine. Second, he stressed the great importance of the evidence to the Crown's case. Like we said, it was the only real evidence for 18 counts, including the most serious ones carrying potential life sentences. Without it, those charges probably collapse.
Okay, reliability and importance. What was the third reason, the one that became the focus of the appeal?
Right. The third reason was what he called the notoriously difficult nature of getting evidence in child abuse cases, especially from very young children. He framed this as the difficulty of obtaining the evidence factor under Section 138(3). He essentially reasoned that because it's so hard to get this kind of evidence lawfully, the desirability of admitting these reliable admissions, even though obtained improperly, outweighed the undesirability of the police misconduct. Public interest in convicting for serious crimes, where evidence is scarce, tipped the scale for him.
So he used the difficulty of the investigation to justify admitting evidence obtained by cutting corners.
That's certainly how the appeal court later saw it. At the time, Judge Madgwick acknowledged it was a tough call, but felt that balance favored admission.
What about the other argument under Section 90, that admitting it would be unfair?
He rejected that too. He said the formal caution Detective Gibson gave on the tape at the start of the ERISP sort of cured any earlier unfairness or issues with Bowman's comprehension. He felt it wasn't ultimately unfair to admit reliable admissions, given Bowman had received legal advice and cautions. Any residual unfairness wasn't enough to exclude it under Section 90, in his view.
So the end result of the voir dire, despite finding deliberate, serious police misconduct that violated a vulnerable person's rights, Judge Madgwick let the crucial ERISP evidence in, which meant the trial would go ahead with the jury hearing those admissions.
Correct. The trial took place in the NSW District Court in Sydney, March-April 2021. The judge presiding over the trial was Judge Pickering, DCJ.
And Judge Pickering had no choice but to let the ERISP in.
Pretty much. Under NSW law Section 130A of the Criminal Procedure Act, a trial judge is generally bound by pretrial rulings on evidence admissibility made by another judge in the same proceedings, like Judge Madgwick's voir dire ruling. Unless there's a very strong reason based on the interests of justice to revisit it, which apparently wasn't argued successfully here, Judge Pickering had to admit the ERISP-BA.
So what evidence did the jury actually see and hear?
Well, the centerpiece, because of that ruling, was the ERISP video. They watched Bowman's interview, heard his admissions about the games. On top of that, the two child complainants, SS and MS, gave their evidence.
How would they have given evidence, being so young?
Almost certainly via pre-recorded video interviews conducted earlier by specialists, or perhaps testifying from a remote witness room via CCTV link. Standard practice in child abuse cases to minimize trauma and help them communicate. They described the abuse they allegedly suffered.
Who were the lawyers arguing the case before the jury? Any changes?
Yes. For the trial, Bowman was represented by a different lawyer, a barrister instructed by Legal Aid NSW. The Crown's case was presented by a senior Crown prosecutor from the Office of the Director of Public Prosecutions, the ODPP.
So the jury hears the contested ERSP, hears the children's testimony. They have 38 counts to consider. What did they decide?
It was a mixed verdict, but overwhelmingly guilty. Out of the 38 counts, they found Bowman not guilty on 5 counts. And interestingly, all 5 of those acquittals came from that group of 18 charges that relied solely or primarily on the ERSP admissions.
So even with the tape, the jury had doubts about some of those charges.
It seems so. But for the other 13 counts within that same group where the ERSP was still the main evidence, the jury found him guilty. And critically, they found him guilty on all 20 counts that were supported by the children's direct testimony.
Okay, so 13 convictions based mainly on the ERSP, plus 20 based on the children's evidence. That's 33 convictions in total out of 38.
Correct. A very high number of convictions, showing how persuasive the combined evidence, including that contested ERSP, was to the jury. After the verdicts, Judge Pickering moved to sentencing. That happened in August 2021.
And the sentence?
He imposed what's called an aggregate sentence, one overall sentence, covering everything of 11 years imprisonment. With the non-parole period, the minimum time before he could be considered for release, set at 5 years.
Did that sentence cover just the 33 trial convictions?
No, it covered the 33 trial convictions, plus the 12 charges Bowman had pleaded guilty to earlier. So 45 offenses in total were factored into that 11-year aggregate sentence.
Given the severity of the charges, like sex with a child under 10, was 11 years with 5 non-parole considered lenient or typical?
The sources suggest it might have been seen as somewhat restrained. Sentencing is complex, but factors like Bowman's youth at the time of offending, his intellectual disabilities, and perhaps his early guilty pleas to some charges likely played a role in mitigating what could potentially have been a much longer sentence.
So, sentencing happens, Bowman starts serving his time. It feels like the end of the road in the lower courts.
For the district court, yes. But behind the scenes, the legal wheels were already turning again. Bowman's legal team, funded by Legal Aid NSW, but now with a different solicitor leading, started preparing an appeal to the highest criminal court in the state.
And they brought in senior counsel for the appeal.
Yes, a significant move. Bowman was represented on appeal by R.J. Wilson, SC Senior Counsel, often called a SILK, instructed by Legal Aid. Bringing in senior, experienced appellate counsel, often someone with fresh eyes who wasn't involved in the trial stresses, is common strategy in major appeals like this. They're there to find those potential errors of law or principle made by the lower courts.
And who represented the Crown, trying to uphold the convictions?
That was M. Millward, counsel instructed by the Solicitor for Public Prosecutions. Her job was essentially to defend Judge Madgwick's original decision on the voir dire, arguing it was legally sound and shouldn't be overturned.
So the stage is set for the second showdown. More than 2 years after the trial, the case lands before the New South Wales Court of Criminal Appeal, the NSWCCA.
Exactly. The appeal hearing took place on July 21st, 2023. A more formal setting. Supreme Court building in Sydney. The bench comprised 3 senior judges, Justice Kirk J.A., Justice N. Adams J., and Acting Justice R.A. Holm A.J. Justice Kirk, as noted, has a reputation for being very meticulous on evidence law and fairness issues. Bowman himself participated via video link from prison.
And the core question for the appeal court wasn't just, did we agree with Judge Madgwick? It was about finding a specific legal error, right? That House v. the King thing.
Precisely. They weren't there to simply reweigh the evidence or substitute their own discretion for the trial judges. They had to determine if Judge Madgwick ADCJ, whose ruling bound the trial judge, Pickering DCJ, had made a demonstrable error in law or legal principle when he decided to admit the ERSP under Section 138.
What were the main points R.J. Wilson SC argued for Bowman?
Wilson SC went straight at the Section 138 ruling. He argued Judge Madgwick fundamentally got the balancing test wrong. He characterized the police conduct ignoring the lawyer, ignoring the mother, pushing ahead with a vulnerable suspect as not just improper, but a deliberate, flagrant breach of fundamental rights and the Lepore rules. He called it substantially improper, a significant departure from minimum standards.
And he zeroed in on that specific factor in Section 138, the difficulty of getting evidence.
Yes, subsection 3, the difficulty, if any, of obtaining the evidence without the impropriety. Wilson SC argued Judge Madgwick wrongly treated the general difficulty of investigating child abuse as a reason favoring admission of the improperly obtained tape. He argued, citing the High Court in Kadir v. Queen, that when the impropriety is deliberate, which Judge Madgwick himself found Gibson's actions were, that difficulty factor should actually weigh against admission.
Why against? That seems counterintuitive at first glance.
The reasoning from Kadir, which Wilson SC adopted, is about deterrence and upholding standards. If courts excuse deliberate rule-breaking just because a case is hard, it rewards those shortcuts. It tells police there's no real incentive to try harder to get evidence lawfully, especially if the evidence they get unlawfully is important. Wilson argued Judge Madgwick's approach effectively deterred the wrong thing, as Justice Kirk later put it.
And this misapplication of the legal principle from Kadir, that's the House v. the King error, he alleged. Can you just quickly recap what that means again?
Sure. House v. the King sets the test for overturning a judge's discretionary decision, like admitting evidence under S-138. You can't just disagree with the outcome. You have to find the judge made a specific error in the process, acted on a wrong legal principle, like misapplying S-138 here, considered irrelevant factors, failed to consider relevant ones, or reached a decision so unreasonable it must involve an error. Wilson SC argued Judge Madgwick's mistake on S-138 was exactly this kind of error of principle, legally requiring the appeal court to intervene.
Got it. It's about a flaw in the reasoning, not just the result. How did the Crown lawyer, M. Millward, counter this?
Ms. Millward argued for restraint. She urged the appeal court to defer to the trial judge's assessment, as he heard the evidence directly in the voir dire. She said Judge Madgwick did consider all the relevant factors, the impropriety, the vulnerability, and the seriousness and importance of the evidence. She argued his decision to admit it was a valid exercise of discretion, even if the appeal judges might personally have balanced things differently. She stressed he acknowledged the misconduct, but simply concluded in this specific context that suppressing reliable evidence of serious child abuse would be more detrimental to justice than admitting it, despite the flaws in how it was obtained.
Was there any debate about whether House v. the King was even the right standard?
There was some discussion about that, yes. Whether S-138 decisions should be reviewed for correctness, meaning the appeal court can just substitute its own view, or under the stricter House v. the King standard for discretion. The law on this was a bit unclear.
Did they resolve it here?
No, Justice Kirk noted the complexity, but said they didn't need to definitively decide that broader question in this case. Why? Because they found a clear House v. the King error had occurred anyway. And once you find that specific type of error, the appeal court has to step in, regardless of the correctness debate.
So the finding of a House v. the King error opened the door for them to overturn the original decision. What was the final judgment from the Court of Criminal Appeal?
It was unanimous and pretty resounding. Handed down on October 11, 2023, all three judges agreed. Bowman's appeal was upheld. The convictions from the trial could not stand.
Wow, unanimous. What were the core findings in Justice Kirk J's main judgment?
Justice Kirk laid it out very clearly. First, he found Judge Madgwick did make a legal error in his Section 138 Balancing Act. Therefore, the ERISP interview should have been excluded from the trial right from the start.
What did the appeal court say about the police conduct itself? Did they agree with Judge Madgwick's assessment of it?
They certainly agreed it was improper, but they really emphasized the seriousness of it, particularly given Bowman's vulnerability. Justice Kirk reiterated that Bowman was entitled to those late-brow protections, and the police had blatantly ignored them. He agreed Gibson's conduct wasn't just a mistake, but a deliberate and very serious impropriety that went to the heart of acceptable police conduct, and essentially wiped out the safeguards meant to protect vulnerable suspects. And crucially, the appeal court explicitly endorsed R.J. Wilson SC's argument about the legal error involving Section 138. Justice Kirk found Judge Madgwick did err in how he weighed the difficulty of obtaining evidence lawfully. Citing Kadir again, he stressed that when impropriety is deliberate, the difficulty factor weighs against admission. By weighing it in favor of admission, the trial judge had indeed deterred the wrong thing, rewarding the unlawful shortcut.
So that misapplication of the Kadir principle was the specific House v. the King error they identified.
Exactly. That error of principle meant Judge Madgwick's entire balancing exercise was flawed. The NSWCCA then performed the balancing exercise correctly. They concluded that the desirability of admitting the ERISP did not outweigh the extreme undesirability of the deliberate and serious misconduct used to obtain it, especially from a vulnerable person. Justice Kirk also pointed out there was absolutely no urgency in the situation that might have even begun to justify cutting corners like that.
And because the ERSP should have been excluded, its use at trial meant
It meant a substantial miscarriage of justice had occurred. The jury had convicted Mann based on evidence that was legally inadmissible. Therefore, the trial outcome had to be overturned.
Which must have led to some really dramatic orders from the appeal court. What exactly did they order happen next?
Yes, the orders were significant and had immediate consequences for Mann, who had been serving his sentence for over 2 years by then. Based on finding the ERISP inadmissible, the NSWCCA ordered. First, they completely overturned Mann's convictions on 13 counts. These were the specific counts identified as relying solely or primarily on the inadmissible ERSP confession.
Quashed. And what replaced those convictions?
Judgments of acquittal. This is huge. It means he is legally innocent of those 13 charges, and because of double jeopardy rules, he can never be retried for them. Poof. Gone. Likely, many of those serious charges fell into this category.
Okay, what about the other 20 convictions, the ones where the children had testified?
The court quashed those 20 convictions as well. But crucially, instead of entering acquittals, they ordered that these 20 counts were subject to a retrial if the Director of Public Prosecutions chose to proceed.
So, not cleared on those, but the slate is wiped clean for a potential new trial, this time without the illegal confession.
Exactly. The prosecution would have to prove its case again, relying only on the children's evidence and any other legally admissible evidence they might have.
And his sentence, the 11 years.
Also quash. Because it was based on the total number of convictions, which was now drastically reduced. The whole matter was sent back down to the district court. Mann needed to be resentenced just on the 12 charges he'd pleaded guilty to way back at the start, plus any convictions that might result from a retrial on those 20 counts if a retrial happens and if he's convicted again.
So the practical effect was immediate.
Very much so. Many convictions evaporated. Mann, having served a chunk of time already, suddenly faced a potentially much shorter period of incarceration, depending on what the DPP decided about those retrials and the eventual resentence. The case was listed back in the district court for October 20th, 2023, to start managing that process.
That puts the DPP in a tough spot, doesn't it? They have to decide whether to put the children and the family through the trauma of another trial, relying only on evidence that isn't the confession.
It's a very difficult decision for the prosecution. They have to weigh the strength of the remaining evidence against the public interest and the impact on the victims. It's possible some or all of those 20 counts might be dropped if the evidence, without the RSP, isn't considered strong enough to guarantee a reasonable prospect of conviction.
And as you mentioned, it's a tragic situation for the children's family. The police misconduct aimed at securing a conviction ironically leads to more uncertainty and potential re-traumatization for them.
It's the terrible paradox. Justice Kirk's point about the lack of urgency seems particularly relevant here. If the proper procedures had been followed from the start, perhaps a secure conviction could have been obtained without this prolonged legal saga and the distress it causes everyone involved.
So this Mann VR decision really made waves, didn't it? What's been the broader impact beyond Mann's specific case? How has it actually changed legal practice in Australia?
Oh, huge waves. It was seen as a landmark ruling. Defense lawyers, legal aid bodies, Indigenous legal services, they hailed it as a major win for the rule of law. It sent this incredibly clear signal. Police must follow the rules, especially for vulnerable people. Otherwise, the evidence they gather, no matter how crucial it seems, can be thrown out.
So it directly impacts how Section 138 of the Evidence Act is interpreted now.
Definitely. It powerfully reinforces that Kadir principle about deliberate impropriety. It makes it crystal clear that the difficulty of obtaining evidence lawfully weighs against admitting tainted evidence if the police deliberately broke the rules. It tells trial judges they need to be very willing to exclude confessions obtained improperly, especially from vulnerable suspects where the misconduct was deliberate. Commentators noted it struck that vital balance acknowledging serious crime but insisting that courts won't tolerate cheating the system.
Has it actually changed anything on the ground in terms of police operations?
It appears so. The case reportedly became a major discussion point in police training. The NSW police force circulated internal memos specifically reminding officers about their duties under the Libere regulation regarding vulnerable persons and the right to silence. Critically, the police commissioner ordered a review of interview practices specifically concerning Aboriginal suspects and those with intellectual disabilities, aiming to prevent a repeat of what happened in the Mann case.
Did the police watchdog, the LECC, get involved?
Yes, the Law Enforcement Conduct Commission. They were already looking into systemic issues where police were interviewing suspects after they had invoked their right to silence. Mann VR became a really prominent, high-profile example of this exact problem, adding weight to the LECC's calls for reform. Their report suggested some officers had basically forgotten or ignored the protocols for vulnerable people.
What did the LECC recommend?
Better training, especially for custody managers, who are supposed to be the gatekeepers of these rights. Clear procedures for recording when a suspect refuses to speak, and importantly, disciplinary action for officers who breach the rules. Following the Mann decision, news reports indicated that 3 officers involved in the case were facing potential disciplinary action, potentially demotion, for lacking common sense and basic respect for fairness in how they handled Bowman's interview.
So real consequences for officers and policy changes. What about the impact for vulnerable suspects and the legal services helping them?
It's become a really significant case for them, a touchstone, as the sources put it. Community legal centers, the Aboriginal Legal Service, they use Bowman's story to educate clients. You have the right to remain silent, and the police must respect it.
And it highlights the importance of having support people and lawyers involved early.
Absolutely crucial. It shows how vital the roles of Mrs. Mann, the mother, and Miss Gagidlo, the ALS solicitor, were in trying to protect his rights. And even though the police initially overrode them, the appeal court's decision proved that ignoring those safeguards ultimately backfires. It showed that these rights aren't just theoretical. Disregarding them can lead directly to evidence being excluded and convictions being overturned. It gives those rights real teeth.
So it's a complex case with, as you say, no real winners given the underlying allegations and the ordeal for everyone, but it definitely seems to offer some vital lessons.
Undeniably, it's a stark reminder that how justice is done matters just as much as the outcome. Police have enormous power, necessarily so, but it comes with a profound responsibility to act lawfully and ethically, particularly with society's most vulnerable. Cutting corners, especially when it involves overriding fundamental rights, ultimately damages the integrity of the justice system itself.
This whole saga, Mann VR, it really is a human story tangled up with these critical legal principles. You see all the players, the mother fighting for her son, the lawyers navigating the courts, the detective making that fateful decision, the judges tasked with correcting the errors.
Yeah, and that quote, attributed to Justice Adams during the hearing, really resonates. If the law loses its way in pursuit of one guilty man, we all pay the price.
And the Court of Criminal Appeals decision here was fundamentally about trying to ensure the law didn't lose its way, even when faced with deeply disturbing allegations.
Exactly. The core message seems to be that the rule of law protects everyone, especially the vulnerable. Fair process isn't just a technicality, it's the bedrock of legitimate justice. Ignoring it, especially when dealing with vulnerable people exercising their rights, has serious consequences. Bowman's case is a powerful, lasting illustration of that principle. The ends simply don't justify means that violate fundamental rights.
So as we finish this deep dive, maybe here's something for you, the listener, to think about. What responsibility do we all have as a society to make sure those legal protections for vulnerable people of disabilities, Indigenous people, young people, aren't just words on paper? How do we ensure they're actively understood, respected, and upheld by those enforcing the law every single time? How does the justice system strike that incredibly difficult balance? The balance between the absolute need to investigate and prosecute horrific crimes like child abuse and the equally absolute need to protect the fundamental rights of every suspect, particularly those who are already disadvantaged by their circumstances. Where is that line, and how do we make sure it's never crossed?
That is the fundamental tension, isn't it?
Yeah.
A question this case certainly forces us to confront.